Good morning. The judgment which I am going to discuss with you would help you. We are conducting a trial wherein multi number of accused were being implicated under section 148 and 149 IPC along with 302, 307, etc. etc. See, the judgment also discuss about how to test the veracity of injured witness. Then they also stated whether the statement given by one of the victim at a hospital, which was registered as an FIR, is legally valid or not. Apart from that, they have categorically held that rule of prudence should be applied under 149 IPC because the mere presence as an unlawful member of the unlawful assembly is sufficient to punish him if anything had happened, offense have been committed by that unlawful assembly. This is AAR 2025 Supreme Court 4941. AAR 2025 Supreme Court 4941. Then Jainul versus State of Bihar with Satar and others. So actually trial was conducted and some of them all were convicted, some of them were acquitted by the High Court. Then dismissed the appeal preferred by this some of the accused. So I would like to share now the ratio and the discussion. First is member of unlawful assembly with common object had allegedly assaulted informant parties to forcibly dispossess them from settlement land. So injuries on eyewitness at the best may ensure their presence at the scene of occurrence, but that was not enough to convict accused for committing offence. So then they say oral evidence of injured witness on whose police statement FIR was registered stood at variance with his further bayan. Eyewitness in the police statement recorded 161 had gone to the extent of implicating even those persons who are ultimately not arraigned and accused in charge sheet, including those who ultimately came to acquitted by the accused. These all are there. Then ocular version eyewitness of contradicted medical evidence. Therefore, that was also there. Then common object has been discussed at that is para 46, 47, 49, 50. This is most important. 149 IPC stipulates that if an offence is committed by any member of an unlawful assembly of 5 or more persons in prosecution of the common object as defined under section 141 IPC, that assembly or if the members of assembly knew that the said offence is likely to be committed in prosecution of common object. Therefore, they say it should be appreciated. The evidence must be appreciated with prudence. So, who were merely passive onlookers, who had joined the assembly as a matter of idle curiosity without the knowledge of common object of assembly, since such person cannot be said to be members of unlawful assembly. Then innocent bystanders. A mere bystander to whom no specific role was attributed would not fall within the ambit of 149 IPC. So rule of prudence should be applied, they say. Then the most important injured eyewitness, they say the testimony of an injured eyewitness is accorded a special status in law because the injuries on the person lends credence to fact that the witness was present at the scene of occurrence. Then they say initially some FIR was registered about some other offences. Subsequently, the police officer went to hospital and received a complaint from the victim and registered FIR. Therefore, say evidence of injured eyewitness and medical officer indicated that information about commission of had reached the police much prior to recording of statement of informant, injured eyewitness at hospital. Statement of informant cannot be treated as FIR. This is most important. We have multi number of pages and go through it. It will be helpful to segregate the accused if a multi number of accused are just like Armstrong murder case and other cases. Best wishes.